In this session, I want to cover some additional exemptions that we have available in Missouri. Let's take life insurance. Life insurance has two separate exemption statutes within 513-430. The first one is term insurance. Term insurance is protection only, where a term policy has no cash value. So when we list your exemption, we want to put down the name of the insurance company. Maybe it's a $100,000 term life policy. You'll put down the policy number. Claim it as $1 in value because you have, number one, an unlimited exemption, and the policy won't have any cash value unless and until someone dies. But you do need to list it. The second exemption for life insurance is whole life insurance, where your policy has a cash value. And again, it's a very generous exemption. The insurance companies undoubtedly went to Jefferson City and used their political influence to make sure that people wouldn't be hesitant in buying life insurance. So you've got $150,000 coverage for the cash value of all your policies. It's a very generous exemption. Alimony. If you're receiving alimony or support, you have an exemption for up to $750 per month. Workman's comp. This is one you need to be very careful of. If you have a claim that's pending, where you hurt yourself at work and you've made a claim and nothing's been resolved yet, you may be receiving workman's comp benefits, but your case has not been settled. That's a pending claim. That is fully protected. It's an unlimited exemption. So you'd want within your bankruptcy petition to declare the date of injury and the employer where you made the claim, and the claim number, your workman's compensation claim number. But you don't need to worry about it because, again, it's a fully protected asset. It's unlimited. The other workman's comp, and this is one where uninformed attorneys get into trouble. If you are already settled, if you've already settled your workman's comp claim, and you are receiving monthly benefits as a result of that settlement, then you are only protected up to the amount necessary for your reasonable living expenses. So that's a little different. You need to watch that. Your schedules I and J, that's your future monthly income and your future monthly expenses after filing day. We project what your income and expenses are going to be into the future. You and I, when we prepare your income and expense schedules, we're going to want to make sure, always being truthful, of course, but we're going to want to make sure that we prove up that you need that workman's comp benefit to meet your monthly living expenses. Don't get trapped on that. Professionally prescribed health aids, that's, again, an unlimited exemption. If you've got breathing equipment or hearing aids or wheelchairs or whatever else, you list them as an asset in your bankruptcy and they're fully protected. You don't need to worry about that. The last category is all-encompassing. These are your retirement benefits, including Social Security. There are different statutes. Social Security has one statute that protects you. Veterans benefits are another statute. Employer-sponsored retirement benefits because of how long you worked for the company, or maybe you became disabled or illness. Just retirement benefits in general. Those are all unlimited exemptions. This is one you need to be careful about. If you're receiving wrongful death benefits, you were a dependent of a person that was killed, and there was a wrongful death settlement or lawsuit, and you're receiving benefits, that works just like that rule for workman's comp settlements that you're receiving. We're going to have to prove in the bankruptcy petition that you need that money for your monthly income and expenses. So in conclusion, let me warn you about something that gets mixed up a lot of times. If you were involved in an auto accident and you've got a claim against somebody, there's no Missouri exemption to protect you on that. So before you file bankruptcy, you will hopefully be able to settle the lawsuit, get the money, and invest it in protected assets. If you don't, then the trustee is going to take over your lawsuit. The money will be paid pro rata, whatever recovery is, to your unsecured creditors. Now, after you file your bankruptcy petition, if you've got a pending personal injury claim, you are under no obligation to continue pursuing that personal injury lawsuit. So the trustee may call you up and say, well, debtor, I will agree to give you 50% of the recovery if you will continue to prosecute the lawsuit. So you'll want to work with that. But the trustee powers in those cases are immense. He can fire your personal injury attorney and hire another one if he wants to handle the settlement. So I know a lot of attorneys don't mention that to their clients, and it gets them into trouble. Lastly, if you've went through all of these exemptions and you've got one or two assets that are not protected by an exemption, don't transfer them to an insider. You need to sell that asset, full value, and then invest the proceeds in an exempted asset. That's the way to do it. If you become a client of mine, I've got a number of recent cases, and they're very, very helpful discussing that it's fully legal and appropriate to sell assets and then invest in exempt assets. There's one case where the people took $50,000 or $60,000 and invested in assets on the very day they filed bankruptcy. And the Court of Appeals in St. Louis said that was okay. So if you become a client and you've got non-exempt assets, then you and I need to work and make sure we transfer those into protected assets. Thank you.